This presentation also builds on previous research within trial first with Madalina on a text that we wrote together back then, and also on another project that will be mentioned at the end of my presentation, where I have worked together with a colleague, Sorina Doroga, who is also one of the Romanian Bar Association experts in this Trial 2 project. So she will participate in the project as well. That second research was rather an empirical research, so I have used some data from that empirical research in this presentation of mine. And indeed, I will refer to the way in which the associations of judges have contributed to stop the backsliding of democracy in Romania. And I will mainly focus on their informal strategies, communication strategies, most of them, and on the way in which they use the preliminary ruling as a strategic tool that would be a formal instrument used sometimes informally or having this informal component as well. But I will also start with the context as Agnes did. First, the legal context, and I have mentioned the most important texts that are relevant in this discussion. Obviously, the Constitution, first of all, with the first article enshrining the basic values that the Constitution protects, among which the rule of law, and also a last paragraph of the same article mentioning the supremacy of the Constitution in Romania, which obviously has become a tensed disposition, a tensed provision during the period of a potential backsliding in democracy, because this was contrasted with Article 148, paragraph 2 of the Romanian Constitution that speaks about the compulsory value, the mandatory character of the European Union provisions that are compulsory by their nature. So there has been a tension between the supremacy of the Constitution and the primacy of EU law that is enshrined in the Constitution as well. There is a very interesting debate on this specific point, but this is not probably the framework, the time framework that would allow for it. And also a provision that was later on revised in the Romanian legislation, according to which the non-compliance with the decisions of the Romanian Constitutional Court or the High Court of Cassation and Justice constituted for the magistrate a disciplinary offense. That was later on changed, but it was in force and it is relevant for the discussion. Then there is the context, the factual context, the years that are relevant for Romania. 2017, massive anti-corruption street protests against the government's ordinances decriminalizing graft offenses, dismissals later on, or attempted dismissals of head prosecutors of the General Prosecution Office, and the creation of the special section for the investigation of offenses within the judiciary. That was 2017-2018, and then up to 2019, enactment of 5 government emergency ordinances, altering the judicial accountability regime and increasing the role of the executive. The context can be summed up as follows. There is a very short period of time with emergency ordinances of the government enacted, with a broader scope touching upon the criminal justice as well, not only upon the judiciary, and a positive part as well, the existence of the mechanism of cooperation and verification that was only lifted last year, which helped and made more difficult the backsliding of democracy in Romania. But also, and this is typical for the Romanian context, the part played by the Romanian civil society and the associations of magistrates in the attempt to oppose the democracy backsliding. And here comes into picture the statistic that we have made. They referred to the requests for preliminary ruling that were proposed by the Romanian courts in the period from 2019 until 2022, so at the end when the crisis seemed to be at its peak, and then the years that followed. And we have within these 3 years that I have mentioned, 24 rule of law requests for preliminary ruling. And in 2019, which is the most problematic year, 11 such requests. The average, the general average of requests is 18 per year. And we had in that specific year, 11 rule of law requests, which explains and gives an example of how active the courts have been in order to get the assistance of the Court of Justice through the mechanism of Article 267 of TFEU. And then if we compare the overall number of references for a preliminary ruling since the accession of Romania to the European Union and until 2022, which amounts to almost 300, we will have about 8% of rule of law requests, which means that the instrument has indeed been used as a means of strategic litigations by the national courts, empowering the national judiciary, and as compared to what Agnes has just mentioned, providing the European Court of Justice with the opportunity to help within the given situation. Because of this high number of references, and because of the fact that within this period of crisis, neither the Romanian Constitutional Court nor the Romanian High Court of Cassation and Justice have been captured. However, the number of requests has been so great. The doctrine has spoken about exceptionalism. They have said there is an exceptional situation in which the magistrates the courts hurried to refer, despite the fact that the situation was far from being as bad as the one in Hungary or Poland, because in fact the number of references from the Romanian courts is very similar to the number of references from the Polish courts, whereas the situations are not comparable. And then, which is the position of the judicial associations in Romania? They obviously exercise their right to set up or join associations, which are non-profit associations prescribed by law, enshrined, the existence of which is prescribed by law. And the data collected with respect to Romania by the Consultative Council of the European Judges show that within this period, that is the period of reference, there were 6 associations that were very active in Romania, 6 main judicial associations, of which maybe the first 4 were the most active ones. What can judiciary associations do? By their statute, they can protect the rights and interests of judges or magistrates in general or in relation with other actors of the system. Also, within in some cases, their statute mention that they can fight for the protection of the independence of the judiciary. It can appear, it is not in all cases present in the statutes. They can act as a fora of internal judicial interaction, and they can influence in significant areas of the functioning of the judiciary. And I have mentioned some examples. They also interact to various extents with the parliament in the lawmaking process or with the government members. So they have quite a wide range of possibilities that are granted by law. What these associations that were the most active ones did, first of all, they deployed informal strategies, as I have mentioned. And these informal strategies have set the stage for the use of the preliminary ruling as a mechanism of strategic litigation. Which were those strategies? First of all, internal and external communication strategies. A lot of communication has been deployed on multiple levels, triggering a very wide audience from civil society that itself was very active in the period of crisis, and members of the general public, to decision makers in government, parliament, the national judiciary itself. But also it was a form of communication that targeted international institutions and other international networks, and it was a very efficient communication. On the sides of these associations of judges or prosecutors, one can find memoranda, position papers, calls for actions that are signed by lists of judges that are well known with their full names and affiliations, prosecutors who endorse the position expressed in the respective document, and their sites are then embedded, or some parts of their communications are embedded in Romania's most important online platform that is frequently consulted by the practitioners and the academics. So the position of these associations that were very active was very well known. The texts were also translated into English or French, which allowed for even a higher broadcast distribution in the abroad, internationally, and this type of communication was expert communication. The persons producing the messages and the texts were obviously at the heart of the judiciary system, knowledgeable, knowing the legislation, also having inside perspective that the academia, for instance, was deprived of. So it was a very valuable communication to the international readers, especially the stakeholders, for instance, the EU Commission, Greco, or the Venice Commission. Then it was the international networking and lobbying, letters submitted to the representatives of the Council of Europe or to the representatives of the European Union, meetings between the representatives of the associations and the members of the European monitoring institutions that were later on recalled and presented on the sides of the associations, as I have mentioned. And this shows that there is an engagement extremely intense. And it is a programmatic use of the communication. It is not just communication that occurs, it is a strategy that is deployed, and it is deployed on various levels. And then there is the last part of this informal means of helping the rule of law and strengthening the rule of law, that is the ghostwriting of the preliminary questions. And we have the co-president of one of these associations, Judge Călin Dragoș, who openly puts forward to the audience that he was among the ones that imagined the types of questions that could be addressed to the Court of Justice in order to help the rule of law situation in Romania. And in a way, these associations acted as whistleblowers. They knew the insides of the system, and they were ready to speak and to warn about the gravity of the situation inside. And then there is the request for a preliminary ruling that is based on this type of informal communication that I have just mentioned. Obviously, this is a formal tool which has been used previously and will also be used in matters that have no connection to the rule of law. But within this matrix of the official channel that is provided by Article 267 TFEU, the national courts took advantage of the Court of Justice's increased willingness to engage with questions that concern the rule of law. And in this way, we have a system that functions from both sides. And indeed, there is a cooperative mechanism. It is not just a question addressed without knowing whether the other party will respond to it, but it is a question that is addressed knowing that the other partner will go half the way or even more in order to support the judiciary in a given situation that is a crisis situation. And what is also important, and I will present another part of statistics immediately, is that these rule of law referrals only activated parts of the judicial network. So we had a few courts, a few tribunals that were willing to refer and that found the opportunity to refer, despite the fact that all of them were competent equally to make references or to adjudicate cases, such as the cases that generated the referrals. For instance, we have 51 Romanian tribunals, only 3 referred. 16 courts of appeals, only 6 referred. I mean, they referred with rule of law questions. And of the 3 referring tribunals, 2 are tribunals inferior to the 2 courts of appeal that referred. So there is also a geographical connection between the courts. And the High Court of Cassation and Justice also referred, but not in the first wave of referrals, but later on when their own competence, their own position in relation with the Romanian Constitutional Court became at stake. So it is as if we have a tacit agreement reached by a small number of pro-European panels of judges or panels within a few courts to use this privileged link that we have at the level of the European judicial system, connecting the national courts with the Court of Justice of the European Union. Of course, this stretched the limits of the mechanism of preliminary ruling, and the Court of Justice was ready to accept this. First of all, and this was obvious from the beginning, and also in other cases, this is not something specific for the Romanian cases. It started probably with the Portuguese judges case and then followed by Republica. There is the problem of the link between the question that is referred, obviously a question that would be provided with an answer helping the rule of law situation at the national level, and the need for the interpretation in order to solve the case, which is the basic element practically of admissibility in such cases. And we have cases, I think it is the Hungarian case, in which the Advocate General admits that in these cases, this connecting element, the link, should be, we should accept that it has other dimensions than the strictly legal one. Then there is the interest to refer. Obviously, all references enjoy a presumption of relevance, but this presumption of relevance can be overturned. There are very clear cases in which are similar to the Miastolovic one, in which the judges involved in referring are judges that are afraid of disciplinary sanctions. Obviously, there is an interest to refer, but the question was, the issue that was more sensitive, I think, was the possibility, and here is where the court had to very boldly interpret Article 19, paragraph 1 of the Treaty on the EU, the situation in which the referrals were meant to, the interest of the referral was meant to cover a systemic risk, which of course was a situation in which the court had to elaborate on the mechanism. And the last thing that I would like to show to you is a case in which maybe it becomes more obvious that there is this kind of relationship that has been built between the national courts that frequently refer, systematically refer, and the Court of Justice, and the strategic element in these referrals, because there is one reference that is made by the Pitești Court of Appeal, which is one of the courts that refers frequently, constantly. And Dragoș Călin explains the purpose of this referral, which would be to allow the Court of Justice to analyze the creation of a new development establishing the legitimacy of unconditional locus standi in situations where the associations of judges seek to obtain effective jurisdictional protection in areas regulated by EU law. For instance, promoting and defending the independence of judges and the rule of law, as well as safeguarding the status of the profession. Now, in this case, again, we will have to accept a development in the use of the referral and in the purpose of this mechanism, because that would restrict or impact the procedural autonomy that is a principle determining the boundaries of the right to refer. All in all, I would say that both these mechanisms, the informal one and the formal one, have been successful. So listening to what Agnes said and to the situation in Hungary, I would say that that most of the fact that the Romanian situation is much better is in fact due to the use of this informal and formal mechanisms. And the project that I was referring to that allowed us to research empirically is the Infinity project that is related to ours, to Trial 2. It was a project building on the informality and the interplay between formality and informality. And the text that I was mentioning, that I co-authored with Sorina Doroga, has just been published. So my presentation today also builds on that text. Thank you very much. Thank you.